case to come before the court is State versus Anderson.
Good morning, Your Honor.
Do you have anybody, we're just like a minute early or so.
No, I don't
You can
have anything
proceed.
that's going to be
All right.
okay.
All right, then we'll go ahead and hear you since you don't have anybody arguing against you, unless you want to argue against yourself this morning.
Your Honor, if the court would just prefer to take this under advisement, I would rely on my brief. If the court would prefer to go that way.
That's completely up to you. We're here, we're ready to pursue whatever you would like to do.
I just wanted to be here in case, reading my brief, the court would have any specific questions regarding this. I think I just got the waiver, I think on the 24th, so it's been about 10 days or so ago. This is a case that I represented, Alex Anderson. He was accused of domestic violence. The victim was his son, Xander Anderson. The matter proceeded to trial. After trial, the jury found Alex guilty of the offense, and he duly appealed. Prior to the trial, his son was subject to Evidentiary Rule 807. The state sought to admit a number of statements that Xander, and I use Xander because they were both Alexander Anderson. The father went by Alex, the son went by Xander. The court held a hearing. It determined that there was enough indications of trustworthiness of the child's statements to a teacher and a medical assistant at the school and a guidance counselor that she allowed all those individuals to testify at trial regarding statements given by Xander. We have appealed 3 specific things in this case. The first was, at trial, there was 2 people that testified that were actually present when this incident occurred. One was Xander's sister, who testified on behalf of the state of Ohio. She was 11 years old at the time. Her testimony, she recounted Mr. Anderson as wrapping a weed cord around her brother and squeezing and also striking him hard enough where he heard the sound. She really didn't have any other recollection, if you read the cross-examination, of anything else that was going on in that particular day. The other person who testified as to what happened at that particular date and time between Xander and Alex was Alex himself. He denied striking him. He indicated he was upset because the weed cord had been damaged, that he disciplined his son, that after that they were wrestling with each other. As a result of that, there were marks on his son. At the end of the testimony of Xander's sister, the trial judge volunteered on her own that the daughter had done a very nice job with her testimony. The state of Ohio, I know, has indicated that this offense is, in their opinion, waived absent plain error. At the time that that statement was made, it was made in front of the whole jury. As a defense attorney, it's very difficult to bring more attention to the statement of the trial judge that was heard by a jury, that this particular witness testified and did a really good job. The concern, obviously, as a defense attorney is that a jury is going to hear this and go, oh, the judge thinks that this person is believable, and in that sense, the judge usurps the role of the jury, which is to determine, in fact, the credibility of witnesses, whether they did a good job or not. That's specifically for a jury to determine. And
but counsel, that's really the reason why we have sidebars. And it's not as if that happened in the middle of, examination and counsel didn't want to interrupt and, as you said, bring more attention. But as the witness is leaving, a statement like that is made, then there's an opportunity for counsel to say, Your Honor, may I have a sidebar?
yes, there is, Your Honor.
And then that gives the court an opportunity to address the issue with the jury by way of,
Potentially it does, Your Honor. It also potentially draws more attention to the statement by the court, and I know that's a very difficult position that, as a practitioner.
How would have it in sidebar, just say, Your Honor, can we approach the bench? The
Yes.
jury's not even gonna know why you're asking to approach the
They
bench.
certainly will after you step back to counsel table and the judge attempts to make a curative instruction, which may do
Well,
nothing
yeah,
more than.
if it's determined that a curative instruction is necessary, but if they just put an objection on the record.
Then at least you have preserved it for us to consider.
Correct. And I do think the court can, if you decide that it was improperly preserved in this case, can consider plain error. I think clearly a statement by the judge in front of the jury about the credibility of a state's witness in a criminal case usurps the role of the jury, clearly affects my client's right to a jury trial and a fair trial. And we'd ask that the court consider it on those grounds.
Of course, that's also the reason why the judge instructs the jury if he or she has done anything that would give an indication to the jury how she may or he may feel about,
That's correct. And I don't think there was a specific instruction given in this case regarding that. A general, my brief indicates that, unless I missed it reading the transcript, I did not.
If the jury instructions are in front of us, we'll review them, obviously.
Pardon?
I said if the jury instructions are in front of us, we'll review them, obviously.
Yes, Your Honor. The next issue which I raised was simply the fact that the background to this incident was Alex and his ex-wife had 3 children, 2 of whom were residing with him, 1 who was residing with his ex-wife. There have been a number of custody battles back and forth filed in this case, and there were the rumblings of a new one that was going to be starting. We were trying to raise that. The trial judge said that was irrelevant, that we were just here for the matters that occurred on the date of the alleged assault. I believe that the fact that there was this backdrop of custody issues between Alex and his ex-wife involving the children could have impacted the credibility of the kids when either they testified in court or statements they potentially made to other individuals that were allowed to be testified to at trial. I believe that was.
Counsel, when I read that in your brief, I thought that that would certainly be a factor where one of the parents is testifying.
Yes.
But you raised that through the children, is that correct?
No, it isn't, Your Honor. I think the state took me to task for not raising it through his daughter, but he attempted to raise it on direct exam. I attempted to raise it on direct examination of Mr. Anderson.
I see.
And then also I attempted to get it in during the testimony of his current girlfriend. Both times I was not allowed to go there by the trial court. And I believe that Mr. Anderson had a right to present any potential defenses they would have had. And obviously the custody issue that I think has been recognized by the Ohio Supreme Court is potentially having some bearing on credibility in situations such as this, and that the judge should not have restricted Mr. Anderson from pursuing that line of questioning. And I believe that, in fact, limiting that line of questioning was prejudicial to Mr. Anderson. And based upon that, we believe that the court has grounds to reverse this matter and send it back for a new trial in which Mr. Anderson can explore those, submit testimony to a jury regarding those issues. There was no specific proffer in this case, but I think it's pretty clear if you look at the record in this case. Mr. Anderson was specifically asked about ongoing custody disputes, how many times they have been in court. He did say numerous. The court then sustained an objection, so it's on. Yes.
If I may, though, if I recall correctly, didn't the child change his story during the course of the school day with the different people that were at the school?
What happened was Xander was on a field trip. His teacher happened to be by him, noticed some marks, was concerned about it. He indicated that he'd been wrestling with his dad, and I don't think the teacher went any further, but and this is totally understandable, directed him to the medical assistant at the school when they returned. And the medical assistant was questioning him, and again, he said it was caused by his father. And then, I believe it was both the medical assistant and the counselor both questioned him, and the initial reaction from Xander was that he had been wrestling with his dad. And I believe the medical assistant, I apologize, I might be getting these two individuals a little bit mixed up, but one of them, their kids wrestled, and she said, well, these aren't any of the marks that I've gotten from kids wrestling. And then the school counselor just pushed him on it and said, well, you know, I know that's what you want, your dad wants you to say, but, you know, I want the truth, which is basically telegraphing to this child that you're not giving us what we want to hear, try something different.
Well, but they were already suspicious because Dad had called in and said, oh, I
Yes.
want you to know that, you know, you might have some marks on him. And they've never had that experience in
That is
15
true.
years or whatever, that some of them had worked in the school system where somebody had kind of like tried to do like a preemptive strike of,
I
so
understand
that's
that.
what raised their antenna to begin with, maybe.
I believe that's absolutely true. You know, it's not something as his counsel that I would recommend that he do, but he did it, and he did it, and it was explained through the testimony. His girlfriend's, or his fiance's mother was a teacher, and told her if there's problems like that, you want to let the staff know what happened. So his version of why he did that was to be upfront with these people.
But
indicate
to
what
my
happened.
colleague's comment about his having changed his story while yet at school, it goes to the issue that you're raising about the relevance of, you know, the trial court not allowing testimony about the custody battle.
Yes, sir.
Neither parent would have been able to influence him between the time he first told the story and then he later changed and said, you know, this is how it actually happened. So.
On that
what's the-
day?
On that day at school. He was
Right,
there
correct. I mean,
at
neither of
school.
the parents were there. But I think the relevance goes to Mr. Anderson's daughter, who did testify at trial as to what allegedly happened. There's only two people that testified at trial that were actually there. It was Mr. Anderson and his daughter. And
And I don't recall whether or not she was questioned at school on the same day. Were they even in the same school?
the record's a little unclear about that. I think she was spoken to, but I don't think there's any synopsis done particularly of that. I think it was more pursued after, not so much by school officials. That's my recollection. And, if I may, the third area that I looked to was the decision by the court that the requirements of Evidence Rule 807 have been met in this case, allowing the teacher, medical assistant, school counselor to testify. The court indicated that, well, obviously this would have been a place where the child was comfortable because he was at school. But on the other hand, every time the child was asked about what happened, his first reaction was to say, I was wrestling with my father. The next step was, well, he was questioned on that by whoever was asking those questions, and that led to a different answer. And I think that undermines the inherent trustworthiness of those statements. And that was the gist of what we were arguing on that case. The state of Ohio, I think in its brief, indicated that, well, we haven't done anything really to bring that to the court's attention. Well, we argued at a hearing that was held on that particular issue in September, and it's part of the record. There's a short transcript with respect to that. So,
Are you suggesting in any way that after the fact, of that day, the daughter and the son, somehow
I don't know what happened between that day and when we got to trial, Your Honor. custody had gone to mother during that time period. She had had meetings with there have been meetings with the State of Ohio Prosecutor's Office, but I can't, there's no record as to what happened during that time period.
I'm just trying to figure out how a 7-year-old would convince his 11-year-old sister to lie months later at trial. If, in fact, that's the only thing I can make out of what you're trying to say.
There's no saying that the 7-year-old would have been the person, Your Honor. I think in a custody dispute, the person that you're more concerned about is the other parent, potentially influencing a child to tell a different
Well,
story.
they'd have to know what the 7-year-old said, so that the stories could jive.
I think they had that. They probably would have had access to all the same police reports that the defense had, plus they had more access to the prosecutor's office, victim's assistance. And I cannot speak intelligently to that because I don't have any of those materials and don't know what conversations they did or did not have. It's the inference that you can draw.
Right.
And
Potentially.
counsel, you're out of time. Thank you.
Thank you very much for your time.
Thank you too. The court will take the